Hey guys, Scott Horne here. With me today is Cassie Solis with Secured Title of Texas.
Thank you, Scott.
Welcome, Cassie.
Thank you. I'm happy to be here.
So, real quick, Cassie, you are an escrow officer with a title company.
That's correct.
How long have you been in the industry?
I've been in the industry for 21 years now. Very, very long time.
Wow.
I'm a glutton for punishment.
Well, you could be. And 21 years means you know about this much more than I do out there. But that just tells you you've been around the block, which means you've seen a lot.
Yes, sir.
As well. You like the business?
I do. There's always something new to learn. There's always a new transaction that pops up and always something different.
Well, good. It keeps it going out there. Let's have some fun and let's just talk about the title industry a little bit, because so many investors have so many misnomers out there about what it is or how it works and things of that nature.
Correct.
And if you're going to be in the real estate investment industry, you have got to have at least a reasonable knowledge of the title company, what they do, how they work, costs, fees, and all that kind of stuff. So in a short, 30-second comment, what is a title company? How would you describe it?
Title company, we are here, we're insurance. We're here as a protection for those who are buying, selling, investing, or those helping others do that in real estate. And we definitely want to make sure that nobody else owns the property other than the new buyer. Seller signs away their interest. No taxes are due. Everything collected that is due. That way we can ensure clear title to the new buyer.
So I just heard you say a couple times is insure. I heard you say that we are an insurance company, right?
Correct.
So just like a car insurance company, a house insurance company, a title company is just that. They are an insurance company. They issue insurance.
Strictly for the title of the property.
Right.
Correct.
So instead of insuring the protection of a car or a home or whatever it might be, a boat, they're ensuring that the title of the home is either good, whatever that might be, or I guess if there is a mortgage company involved who's making a loan, that the lien priority that they are expecting is also insured.
Correct.
And it's backed up by the insurance, which is the guarantee. Is that right?
Yes, correct. We are definitely bound by the lender's closing instructions and the lien position that they are intending when they are lending. So we definitely make sure that all of that is in accordance with their instructions.
And the one problem that means? That means if you're an insurance company, it means you get to be regulated by the state.
That is correct. We are highly regulated.
And they can jerk your strings, and pretty much they control everything, don't they?
Yes, we don't get to make those choices. We are subject to TDI, Texas Department of Insurance, as well as CFPB, the Consumer Financial Protection Bureau.
That's a dirty word.
Oh, yeah, no, you don't
we
like
don't
that.
want to talk about
we
that.
can back that one up.
Yeah, that's not good. But so when you're regulated though, and especially in the title insurance world, 98% of all the costs and fees involved in the title business is dictated to every title company, which is kind of good. So that means we're all dealing apples to apples.
Correct.
So I think really the only thing that we can even control is the escrow fee that is charged to a seller and or a buyer on a transaction. And even that has certain rules and regulations.
That is correct.
What I was told, if I'm right or wrong here, is that if you're going to charge party A for a particular transaction a certain escrow fee, technically you should charge party B, C, D, E, F, Z the same thing, right?
Correct.
You can't mix and match. So if one person just brings you one file, or somebody brings you 100 files throughout a year, you can't give preferential treatment one to the other.
The escrow fee should be the same.
We used to be able to do that years ago. They kind of curtailed that, unfortunately.
Well, refinance lenders like to think that we can change our escrow fee according to their transaction as well.
Everybody asks the question. It's that old saying, if you don't ask, you don't get.
That is true.
And all we have to do is just help people understand what it is and tell them. And, sometimes there's just things that are outside our control, right?
Correct.
So I'm going to ask you a question I hear all the time. Is title insurance required on a transaction?
It is not required. It is optional. You are fully able to negotiate that and decide if that's a purchase you want to make or not.
So,
however, I do recommend it.
well, it's a big deal if you're buying a home.
Correct.
You want to know that you as a home buyer may be protected. And I know certainly a lender that might be making a loan, they want to ensure that they're protected. I find it interesting in the investment world there's a different way you approach things from a retail scenario to an investment scenario.
Correct.
If someone's buying a home retail, let's say they're buying it for $100,000,
Mm-hmm.
and they're going to put, say, 10% down and get a $90,000 loan, you get an owner's policy of 100
The value
and a
of the sales
lender's
price.
policy of 90.
Correct.
Okay, so in that case, you do get protected for the full amount what you bought it for, right?
Exactly.
So think about this though. On an investor transaction, let's say you bought that house for $60,000
Mm-hmm.
and you're going to put $20,000 repair into it. You borrow $80,000 from a lender.
Mm-hmm.
You only get an owner's policy of 60,
Correct, because that was your
not
liability.
the
at
full
purchase.
value of 100.
Correct.
So I try to teach investors sometimes, if you're doing that, you may want to waive the owner's policy and save that money. I hate to take money out of our pocket here and say that per se,
Mm-hmm.
because if there ever is a claim, guys, they only pay one policy. They don't pay both owners and lenders. They're going to pay whichever one's the largest, and that's it. So in that scenario, Cassie, as I've learned, they will honor the $80,000 lender policy
Mm.
and nothing else. Now, I think, tell me if I'm right or wrong here, you can buy up to the value of the home if you want to pay for it, I believe. But I don't see that happen very often, do you?
No, actually, I have not seen that in my time frame. I know that that is possible with, the correct documentation that could be requested.
Okay. So there are two basic types of title policies out there, is that right?
That is correct.
What are they?
We've got the owner's title policy that is going to protect the person purchasing the property as the owner,
Mhm.
and make sure that nobody else has interest in the property, taxes are paid, that they are covered there. And the next one is our mortgage title policy. So the mortgage title policy is for the lenders. So it's going to insure them as well as their lien position on that property.
Okay. So, obviously, if you're the home buyer
Mm-hmm.
and you're buying a house, you have the option to purchase an owner's title policy,
Yes, sir.
or not, I guess. I guess if they wanted to, they could refuse it, couldn't they?
Yes, they could. They could actually negotiate and say they don't want the insurance and, take that additional cash for themselves towards their transaction.
So they could actually, so for instance, if the seller is going to
Pay the cost of
pay
the
the
owner's
cost of the policy,
Correct?
they could waive that owner's policy and see if they would be willing to apply that, where they simply take that. Now, if they're getting a mortgage, that lender's still going to want a mortgagee's title policy, right?
And if you don't purchase them together, the cost of the lender's title insurance is equal to an owner's policy by itself.
Right.
So the second policy is you're only an additional $100. So you're already going to float the cost, the major cost for one policy or the other. It's in your best interest to get
So
the second policy,
It's a minimal cost and expense.
to
for
get the
some
additional coverage.
coverage.
Exactly.
Now, from an investor scenario guy, remember it's an inverse scenario where typically your lender's the amount of your loan is well in excess of what your owner's policy would be. So only in that instance you probably wouldn't want to get an owner's policy, but you still may.
Mm-hmm.
But if you're doing a retail deal where you're maybe an owner occupant, yes, you do want to get it.
Most definitely.
So I get all that. Now, if I'm buying a property, I want to get an owner's title policy. And guys, we call that an OTP in the industry out there.
Correct.
You can ask for certain endorsements
Yes.
to that owner's title policy.
There are a number of available endorsements.
Yeah. And I'm not going to bore you guys with what all of those are, because there's a plethora of them. And that would be, Sominex on steroids probably. But every endorsement does cost a little bit of money, right?
Correct.
But that's out there and available for homeowners if they want
And the
those
majority of them have a standard cost. There are some that are going to be subject to a percentage of your loan amount or your sales price,
things. Okay.
depending on the policy.
And so then we have this thing called the mortgagee's title policy, right?
Mm-hmm.
And that's your lender's policy, as you said, that's out there. And who kind of directs that?
We are subject to the lender at that point. They are going to tell us what they need in order for us to insure, in order for them to lend and finance on the property.
Okay. So they kind of give us instructions, and we have to follow those instructions. They may ask for, the one thing that's typical is a survey deletion, where they want to make sure that they're protected on the number of acreage or square footage that they're lending upon in some
Correct.
format out there. Normally on a residential lot, that's not too big of an issue. But if you're doing a big land deal, it becomes a major issue, of course.
Yes. Yes, a residential policy, it's gonna cost you about 5% of that premium.
Right.
Commercial, it's gonna go up to 15% of
Right,
that
so it's a
premium.
big jump, isn't it?
Yes,
So that's just, again, everything's a cost of money, guys. So you get out of that. Sometimes, though, there are transactions where they think they're closing in a title company, right?
mm-hmm,
And they really don't, because title insurance isn't being issued.
correct, and if your contract does not state that title insurance is being purchased, as a title company, we are not gonna open that transaction, we're gonna refer you to a law firm.
Okay. So in other words, a transaction, a title company does not close any transaction unless title insurance is issued.
Correct.
So you may think you might be going to a title company and walking in the door that says ABC Title Company,
Mhm.
but really, if you're not getting title insurance, you're closing in a law firm related to that title company property, right?
Without an actual policy being collected for or issued.
Okay. So, another thing I see so much of is these, I guess it's the best word to use for it is double closings. It's the A to B, B to C deal.
Correct.
And I know for us, we see a huge number of those things, and there's so many ways to look at this.
Mm-hmm.
And it's so important for the investor world to have a good grasp of how that stuff works.
Yes.
So let's spend a moment just talk about some of that a little bit.
Okay.
So, we have a Mr. Investor out there wants to, he has a contract, he's going to assign his contract, like better word, to a buyer. He's got some options.
Okay.
What's the first option he's got out there?
You can obviously assign the contract for an assignment fee, as
Okay.
you discussed. And
So let's talk about that real quick.
Mhm.
So if there's going to be an assignment,
Mhm.
guys, you got to have an assignment of contract in writing. That's the first thing, right?
Correct, and that's gonna detail us what your assignment fee is, and then it also lets us know that you have obviously assigned your initial contract to that new buyer.
Yep. One thing I see so much, Cassie, right now is a lot of people in the industry think that those simple words and or signs on a contract is sufficient for a seller to be bound to that verbiage. And here in Texas, at least, it is not. There's actually some legal verbiage that needs to be added into a contract in order to force a seller to honor an assignment of contract. So guys, if you don't know that, reach out, contact us and ask so you can have that proper verbiage in your contract for your protection out there in that regard. So you can assign a contract. Of course, that's the simplest and easiest way to do it, right?
Yes,
So of course, when you do that,
everybody's gonna see your assignment fee.
everybody, the whole world knows what you just made.
Exactly.
And so many investors want to keep that close to their chest, right?
Mhm.
So if they don't want the buyer or the seller to know what they're making, what are some other options they can consider?
So in that case, a double close could be an option where you have a contract between the owner of the property and the investor or wholesaler, on, as B. Then he would enter into a second contract, so we'd have two separate files, two separate contracts. Second contract would be opened from the B buyer to the C, which is gonna be the end buyer or rehabber.
Okay.
And in that case, we have a couple options, and we have what's called a premium pass-through. If the B guy doesn't want to buy a policy on the first one, we can essentially collect it and pass it through on the second transaction. That does require full disclosure to all parties as far as all contracts, and we can only do that through Fidelity. So it does matter. We need to know that sooner than later. That way we open it for the correct
So
underwriter.
what I just heard you say about that is you can do A to B, B to C.
Mm-hmm.
You can only pay for one title policy.
Mm-hmm.
No, it's always good to save money if possible.
Mm-hmm.
But there is a risk that there could be some disclosure. All parties must sign off on it and
Correct.
agree to it. Doesn't mean they will. A lot of times, all they want is their money, right?
Mm-hmm.
So usually you're successful, but not always.
Right.
And guys, I'll tell you, in the commercial world, that's a much different animal than in the residential world.
Yes, it is.
That's out there. But in the whole United States, there's only a very, very small number of title underwriters or the main insurance company. And right now, at least in 2020, the only one we are aware of that does that is Fidelity.
Correct.
Now, here at Title, we do and can underwrite Fidelity when necessary,
Mm-hmm.
just as long as you ask and bring that up so we can
We just
take
need
care
to know
of
when
things
we open that transaction.
appropriately.
Mhm.
So if they don't want to do a double close like that, where they're doing a pass-through, as we call it, do they have another option?
Transactional funding.
So so if you don't know what transactional funding is, guys, that's basically 1 or 2 day type money. Is that right?
Correct. Where we essentially, close both transactions, we get the money from the lender on the end deal, and that funds the front, and it filters the money all the way through. That way we are in accordance with TDI regulations.
So AB actually closes and funds, they actually pay for it. So party C doesn't use their money to pay for it.
In a transactional funding case,
Yeah,
correct.
that's a big time problem to do that. And then once you've actually bought it, you are then able to sell it and close the BC deal, right?
Correct.
Yeah. Now, we love it because we get 2 title policies. Excuse me, we Aggies can't do this, we have to do this, okay? So you get 2 title policies in that regard. There is a cost and expense, but that is a surefire way to ensure the deal closes, it's closed properly, and there's no disclosure of the profit that the middleman is making in the deal, right?
Correct. And I do want to point out too, I want to back up a little bit in regards to assignments.
Right.
If you are going to have an assignment fee, we do have to make sure that is 15% or less of the tax appraised value. Otherwise, we do have to get approval of those transactions for anything over 15%, that assignment fee of the tax appraised value with underwriting. So just want to keep that in mind. That could be an additional hurdle to get through to get our clear to close if those numbers aren't in accordance with
You are
that
exactly
ratio.
right, and we're going to talk about that even more in a moment. But
Okay.
of course, that is a Texas regulation.
Okay.
They put that on us back in the subprime days. They did a lot of stuff in the subprime days we don't like, but there was good reason for it, and it's all protection
Too
mechanisms,
many
right?
bad apples ruined it for everybody else.
They did. So we get through some of the basics there and how to handle some things. I want the audience to understand, what are some of the processes, the time frames, and the basic procedures that we in the title industry have to consider. Because again, guys, you have to have a fair and good understanding of all that. So, it all starts with one thing, right? You gotta have a contract.
Correct.
So they got a contract, what do they do?
Well, they're going to submit their offer. They're going to, hope it gets signed by the seller. And once they get a fully executed contract, they're going to take that to title company and take it to us with their earnest money. And, we see some contracts coming over $1, $5, $10. And, it's definitely suggested to pledge earnest money that is equivalent to the general price of the transaction.
Right. So, don't let my eyes roll back in my head too much here about that $1 or $5 earnest money. I always talk about reasonable earnest money in a transaction. You don't ever want to lose a deal because you had too small of consideration out there. But it does. It starts with the contract. You have to actually deliver it to the title company, give them earnest money. How would you like to see that earnest money delivered to you? What type?
What form of payment?
Yeah, what form of payment?
Certified funds, unless we have more than 10 to 12 days before closing, because then we have time for that check to clear.
So it has to clear. And here in Texas, there's some requirements that you have to get that earnest money in the contract to the title company within 3 days of signing, right?
Correct. And the title company has to receipt it and acknowledge and let everybody know that we've deposited those
So
funds.
receiving means that here in Texas, the last page of the contract, there's a place for the title company to acknowledge that they've received it and receive the earnest money. And guys, when you're in a tight market where there's a lot of competition, you want to make sure you get that signed and dated, because that could be evidence if somebody else tries to come in behind you and put another contract on the property.
I agree.
So it protects you out there a little bit in instance. So once you have that valid contract, which is an offer and acceptance and consideration, you've delivered everything. What do you do now?
At that point, we are going to open title.
Open title.
Mm-hmm.
Okay, what does that mean? What does that entail?
So that is a review of all the records that are filed regarding that property and that subdivision with the county clerk. Now, as a title company, we have an agreement with a title plant. They have a replica of all those records that are held and filed at the county. So we review all of that, search it all, make sure the person who's listed as the seller on the contract actually owns that property. We're going to list all the liens, easements, anything pertaining to that property that's filed of record is going to be listed within that commitment. Schedule C goes in to things that need to be corrected to go ahead and ensure a clear title as well.
Okay. So it's going to find everything.
Correct.
You know, if you've got a utility easement where there might be a power line or whatever type of utility easement could run across the property, or setbacks on your property or survey, those could all be on there. If you have a mortgage lien that has to be paid off or released in some format, judgment liens that might show up on the seller, other items that could affect the property that we have to fix and clear. So when you open title, and let's just look at this from a traditional basis, in a normal market where you don't have some superheated marketplace, and you get a contract and you open it up, what is a reasonable time frame for most title companies to be able to get that evidence of title back in from the plant?
I'd say a reasonable time frame in non-busy times, definitely 3 to 5 days is definitely reasonable.
So that's business days, guys, not
Correct.
weekends, because they're closed on the weekends. I might work every weekend, but the plants don't. So if you got that, but you know, I've seen so much here at least in the Texas marketplace recently, over the last several years, it's been so heated. It was taking forever to get title work. I mean, it was taking, what, 10 days?
10 to 12 days?
More?
I've seen longer.
Yeah. And I mean, of course, everybody was yelling and screaming, and it's like, wait, out of our control, right?
Correct. There's only a particular number of plants in each county. And so if there, is a much higher volume during that season going through that particular plant in that county, we're all going to see it. We're all going to feel it.
Right. So things can happen. Don't be unrealistic. And just because title company A says they can do some miraculous work, it doesn't necessarily mean they can.
Never
Sometimes
hurts to
they
give
can.
us a few extra days.
That's right. So have a little grace for your title people, because
Thank you.
they're going to work really hard for you out there.
Definitely.
So we get this commitment back in, as we call it, right? Now, that's not
Yes.
actually the title policy, but that's
No.
just a commitment.
It's our commitment to insure based off of the terms that are outlined there.
So when that comes in and you see it for the first time, what are you going to do? What are you looking for?
High points. Obviously, I'm going to verify seller is in title. Legal description matches the
That
contract.
helps, doesn't it?
Yeah, you can't sell it if you don't actually own it.
So I'm going to stop you real quick, because we
Sure.
see that a lot.
Yes.
Where the seller is not entitled,
Correct.
but the contract shows somebody else. What do you think?
I mean, at that point, we're going to reach out and we're going to, think, is there a deed that's been recently filed that we haven't seen? And is there an agreement that we haven't been, privy to? We
Like
haven't
two
seen it.
contracts, maybe.
Correct. There could be other things that are happening prior to the transaction that we're closing. And so sometimes you have to just ask questions. You can't make an assumption. Not every deal's fraud. Sometimes you just need some more paperwork.
And I guess one of the most common things I think I see is somebody died. There's
Well,
a probate scenario, right, going on.
Correct.
But nothing's been filed yet.
I've seen one, the current seller who is entitled, took possession of the property in 1939. And she's had possession of that property, and she passed, early 2000s. And then her husband has passed, and now her daughter has passed. There's one remaining person, but through all of those deaths, they never changed title. So now at this point, we're having to sit there and review 20 years of information and hope that there are people still alive to back up that record.
And in our industry, which is the title industry, the investment industry, guys, I cannot tell you how often we see that people think that things just happen magically out there. They don't know what it is. They don't know, unfortunately.
Correct.
And what we have to do then is go back, and that takes such a long period of time. So you see this stuff come in. You want to make sure the seller's entitled.
Correct.
If not, there can be all sorts of issues causing that.
Ask questions.
What else are you going to do?
Legal description. We also want to verify on Schedule B that there is a legal access to the property, and that that's all there. If there is a homeowners association, we're going to reach out to them and find out any fees that need to be transferred and collect all of their paperwork, so we have that when it comes time to prepare the closing statement. And then over on Schedule C, obviously we're going to verify if there's a lien. If somebody's filed a lien against the property, that tells us we need to reach out and request payoff statements and or releases if those things have already been paid, because we see that all the time. There'll be a prior owner lien. They took care of it. We have proof of that. But for, maybe the company's out of business or somebody just didn't follow up, we didn't get a release of record.
Now, that was huge many, many years ago with all the real estate crashes, with the banks that went out of business. They have created some data files for us out there that we can go to that help.
In some cases, FDIC will actually sign releases for those failed banks.
Right, so you get all those kind of things. You know, I see this is so prevalent out there, are of course, people who have passed away, especially in the investor world. There's been no probate, so of course what we've got to do is stop. As you said earlier, ask the question, what's going on?
Right.
What happened? And start finding things out. Now, we always hope that our client has asked those questions in advance.
Right.
I try to train them to do that, but doesn't mean they always do it. And if not, we've got to find out, and then we have to go and put together, maybe for probate, what's called heirship affidavits, and that's really just a mechanism to convey real estate from one party to another. It could be husband to wife, or husband or wife to children, or whatever it might be out there. But we have to go through it, we have to do all that.
Put all the facts of record.
Then there could be all these lien issues, right? And guys, I hate to promo the Owner Finance Network here a little bit, but if you haven't looked at our lien course, you may want to think about that, because you have to have a knowledge of liens in the investment industry.
There's certain statutes and timelines and many ways to kind of maneuver through that stuff if you're familiar with those.
You do. If there's a mortgage lien, of course, you want to look and see, has it matured or is it still valid? A lot of escrow officers don't stop and look at dates and things that I see are so important in this industry. You have mortgage liens, and maybe they've been out there for a long time, but if they've matured and they've gone beyond 4 years past the maturity date, that lien becomes null and void. We might be able to disregard it and move on. You don't see that too often with 30-year mortgages,
right?
But we run into it up here, quite a bit. Then you got things like judgment liens, and this is one of my pet peeves. So if you see a judgment lien, what are you going to think about very first? What are you going to look at?
First thing I'm going to do is I'm going to pull a copy of the actual judgment. I'm going to compare, because we do name searches, so a lot of times we'll, they drop that name in the bucket and we'll come back 20 possible searches, especially if your last name's Smith. Or anything common, we're going to get a laundry list of possible judgments. So the first thing for me is I'm going to pull everything that's coming up. We're going to get all the information on the possible person, date of birth, social, middle name, addresses for the past 10 years. We're going to go through and see if we can cross out and weed out any of those judgments that may not apply. Now, if we get down to a point where there's not enough identifying information, but our customer is stating this is in fact not me, then we can do a not our person affidavit where they sign under affidavit, and under notary stating that's not my judgment.
So if they're fibbing, that's kind of like perjury, right?
Correct, and that would fall on them. That liability would fall to them.
Yep. So let's assume for a minute, though, it is them.
And if it is them, there are certain options. Next question to ask, is this your homestead property? If it is your homestead property, there are certain things that can be requested or done to potentially get a partial release from your homestead property.
I find it actually incredulous that our legislature did something smart not too long ago.
Yeah.
And because it was a big issue with these, because attorneys for these judgment creditors would play games knowing it would delay the closing. And of course, they're trying to collect money for their client, right?
Correct.
Well, luckily we have this thing here in Texas today called an affidavit of homestead and release of judgment lien, where you give them a chance to do the right thing by releasing the judgment lien through a partial release.
From the homestead property.
Doesn't mean they release the judgment, but just as to the homestead.
They're not going to come after that property for payment.
They can go after anything else they wanted to,
Correct.
just not the homestead. But they won't do it. So in this case, we have this affidavit that we can send notice, wait 33 days, that's for mailing included, and if they don't execute a partial release, we can have the client sign it and it acts as a removal. That was one of the best things since sliced bread in the title industry, I think.
Yes.
To help us out there.
It also makes them kind of want to negotiate with you and want to respond to your requests and possibly come to an agreement outside of closing with them getting nothing.
Absolutely. But so often they just ignore it, as I've seen. But again, it's one of those kind of things. But what I like, the fact that what we do up here is I don't want to wait until the closing day and say, well, we sent a partial release of lien, we haven't gotten it back yet, but we're waiting on it. Because that ain't ever going to happen. And I had that too many times where I get a phone call because title company ABC didn't do this. I've got to fix the problem for them so they can then go to closing. But now it's been delayed 33 days, unfortunately.
Right, because you have to do the certified letters and with the time frame.
Yeah. So here at our title offices, at least, we try to get on that day one when it comes in to preempt it, so that let's not wait for somebody to react. Let's be proactive and act ourselves.
Start that time frame, the sooner the better.
Absolutely. So we got probates we got to clear up. We have all types of liens, from judgment liens, child support liens. That's probably one of the, again, more prevalent things we see out there. And guys, in one of our lien classes, we talk about here in Texas, a child support lien cannot attach to a homestead by operation of law as per our Constitution, but title companies, from a business perspective, want it removed. And that's fine, we understand that. And you have to deal with that in certain ways. Trying to go after and force the AG's office to remove it, that's a different ballgame. But you can call and get them released, can you not?
Yes.
It's just that if the seller's making money, they want the bad actor to pay that towards the child support lien, right?
Correct.
Yeah, by the way, I think that's a good thing. That's not a bad thing, because if they're not paying the child support, that's pretty important to do.
Correct.
So, but there are ways of removing it, and we can remove them, right?
For homestead, we have a lot more wiggle room than on a investment property.
And we got those wonderful HOA liens you talked about earlier. And you may have, HOA liens or assessment liens, whatever it might be. And of course, they've got to get paid at closing because the seller signed off on it to agree to allow them to be attached to the property. We got to deal with it and take care of that out there.
Yes.
And sometimes we run across some survey issues. Typically on residential lots, you don't see that much. But once in a while, you'll see where somebody built something over a setback line. And sometimes over a property line by a little bit.
Correct.
And if there's actually a survey, you want to be able to stop and cure that issue, or make sure the parties are all aware of it.
And that they're all in agreement.
That's the biggest thing.
You don't want boundary line disputes after closing.
Right. So another thing I see so often, especially in the investment world out there, is that an investor's buying a property and it's leased. We get down to the closing table and we find out there's a lease on the property.
Oh, there's prorations. There's money. More money needs to be collected. What about the deposits?
And we don't have anything about it. We haven't got a copy of the lease.
Right.
Nobody told us about it.
Correct.
There hasn't been an assignment of the lease issue. We didn't put any lease prorations for rent on the settlement statement.
Unfortunately, we're not mind readers.
No.
Unless they tell us, we're not going to know.
I thought I gave you a crystal ball. You don't have that still?
It's not working, Scott. I
Well,
need it repaired.
Plug it in. Well, but guys, you've got to let us know about this stuff in advance. Not on day 30, on day 1. So we can get a copy of the lease. Make sure you have a copy of an assignment of that lease. Proper prorations of the security deposit. Because if you buy a property that's leased out, you're going to take over that responsibility and you will make certain you're being protected. Now that could be a negotiation and how you handle it between seller and buyer. I get that. But normally, this needs to be prorated at closing and taken care of that way. Now, there's a tax certification, right?
Yes,
And I think that's huge.
it is. We actually, contract with a third-party vendor who, guarantees and searches and provides us a statement with exactly what's due, if there's rollback taxes that are due, if there's tax liens, provides the tax rate.
What is a rollback tax?
So, in the event that you change the use of your land, during a particular year, say taxes have already been assessed, they've already been paid, but the tax assessor finds out later that, you're not using it for agricultural use anymore, but you've got an exemption there, or, it was a farm and now it's a subdivision. Well, the county's gonna come back and say, you changed the use during that year, didn't let us know, so they're gonna roll back and assess that time frame where the use has changed.
So all of a sudden,
After closing, a huge bill can be sent to the title company and say, hey, more money is due.
you got it. And what I see so much in the industry is grandmom passed away. She had a 70 and over exemption. She may have had a disability exemption. She died 5 years ago. When she died, title technically transferred the date of death. Now, they may not change taxes until January the 1st of the next year,
Right.
but 4 or 5 or 6 or 10 years have passed, and no one told the county there'd been a death or a change of ownership.
And they'll eventually find out because
And they
anything
will roll that
reported,
back.
yeah,
And if we as the investor don't be proactive on that as well, we could get hit with that.
Mm-hmm.
The last thing we want to do is try to go sue that seller who has no money or is gone, or it might be,
Right.
but you'll never get it. It's just, you're, for lack of a better word, forgive me, you're pissing in the wind, and you don't want to do that. And so guys, when you have a probate scenario, be careful what you're looking at. So Cassie, I know we talked about some of the probate issues we encountered in title. So from there, we have liens. We got to do what with those liens? We get payoffs, right?
Payoffs and or releases.
So one or the other. I know sometimes we have these mortgage liens that may have been paid off years ago. The mortgage company would have sent a release of lien to the
borrower.
home seller,
Mm-hmm.
probably not the borrower, but they don't know what to do with it. They put it in the file and they don't record it and it doesn't show up.
Mm-hmm.
And then it becomes a cloud on title, and we get the privilege of dealing with it
Correct.
and trying to find people to get it re-executed out there. So there are some issues that pop up, and sometimes it's outside of our control and how to fix that, right?
Mm-hmm. Yes, most definitely.
What other type of payoffs are we going to order out there? So lien payoffs from mortgage companies.
Mm-hmm. HOA liens, judgments, if there's tax suits, sometimes you have to reach out to an attorney.
Mm-hmm.
In cases of HOA liens, sometimes same thing, you're going to reach out to an attorney and not just the homeowner association themselves.
And again, there's that wonderful thing out there called the IRS, right? And, guys, forever and IRS are synonymous. We're talking about getting a release of a lien from them. It can be done, but it is cumbersome, and it takes a long time sometimes to resolve that.
One of the first steps is just appointing the authority to even speak to them.
Right.
They're not going to talk to us on your lien unless you give them that authority to do so.
Another thing, Cassie, I run into, though, is a seller is selling a property to a buyer, and there might be ongoing work
Mm-hmm.
happening on the property. So if you see that, or you know that, what are you going to do?
At that time, all work needs to stop. And there's certain documents, that the lender may present that state that they're guaranteeing that no work has started, that nothing has commenced. And so obviously if they're doing work and the transaction's not final, that's a huge liability for all parties.
Well, normally what I've seen they want to do also is they want us to get lien waivers and bills
Mm-hmm.
paid affidavits. Just to give you a real life example, guys, a very well-known pool company was closing their land here in our office a few years back.
Mm-hmm.
And for some reason, the escrow officer that was handling that closing just didn't feel right. They were too anxious, trying to get things going, and so they're getting ready to close the transaction and put a lien on the property. And she said, Scott, go drive by. Sure enough, we get out there. What's going on? Bulldozers are everywhere. They've graded the lot. They're putting in plumbing and laying forms. We had to stop the whole transaction and closing. Had to wind up getting lien waivers and bill paid affidavits from everybody, because if you don't do that, if work starts before title work is issued,
Mm-hmm.
it can jump in front of the mortgage loan that you're getting. So
Correct.
if you are an investor, you're buying a property, and you suspect work has been done recently on the property, ask the right questions and be smart. Don't risk a lien coming up that could occur and be filed that could somehow jump in front of your mortgage loan from a mortgage company or a private lender or an asset-based lender, it might be, and create problems. And again, you have to know that this happens out there in real life to know how to handle it. So we get all those kind of things that come up, and that's real life stuff. But another thing I know we do is we have to do a thing called bring to date. What is that?
So we're going to, if we did a recent search, when you initially turned in the order, say 30 days has passed, we're going to bring our initial search to date, which means we're going to search everything in that gap from our original search to the current date. Outside of time frames for the county, they're normally a week or so behind on as far as what they're indexing and what we're seeing,
Mm-hmm.
but we bring it as close to date as we possibly can.
Okay. So basically what they're doing, I guess, with the bring to date is, it's a fail-safe to help say that if anything's been filed since the first time they checked it, they're trying to ensure there's nothing else been filed thereafter, right?
Yes, and it's our goal to get a bring to date as close to closing. That way we make sure, if there has been something that's filed, we see it.
Yep.
And we can address it prior to us recording our new documents.
Well, as you know, so I tell stories because that's how people learn. Thank goodness, years ago we were closing a large commercial transaction, and my escrow officer did a bring to date and closed the deal. The bring to date was ordered and brought in on a Monday. We closed the transaction on either a Thursday or a Friday.
Mm-hmm.
And in between just those few days, a $300,000 lien was filed against the property.
Wow.
Had we not done the bring to date,
You wouldn't have seen
we
it.
would have been responsible for the $300,000 loan.
Exactly.
Since we did things the right way, that's one of the risks that title insurance companies
Mhm.
take in the industry to deal with those kind of items that are out there.
Yes.
And really, that is the biggest risk of loss, if you don't know this, that exists in the title industry, are liens being filed in that gap period.
I actually worked for claims for 2 years, and
Mhm.
the worst transaction I saw was something similar to that. There were 8 liens that were filed all in the same day, all different banks, all, totaling up to $8 million.
Oh, wow.
And you search more, come to find out it was a vacant lot, Scott. A vacant lot. So this woman did a little more research. She was a mortgage broker. It was up in New York somewhere, and she had mortgaged one property that was a vacant lot with 8 different lenders all on the same day.
Wonders will never cease, will they?
No.
And, excuse me, investors will do strange things all the times.
This is correct.
No, one of the last things, though, we come across is, of course, oftentimes there has to be a survey to close the deal. I get the retail side, mortgage lenders almost always want a survey.
Mm-hmm.
As an investor closing a property, not too often.
Not
Some lenders do, some don't.
Mm-hmm.
Some investors want it, some don't, and I get that. That's out there. But we have to order a survey, right? Any issues with that you see?
We just need to make sure that whoever is going to be paying for that has agreed to pay for that before placing that order. We want to make sure that our surveyors are paid, obviously, but we also do, want to make sure that we get those surveys in a timely manner and make sure that they are covered for.
So, guys, as a surveyor myself and as the son of an engineer and surveyor, I will tell you that I've seen that one time too many where the surveyors go out, do the work, provide it to the title company, and the transaction doesn't close. And instead of getting paid, they have to eat it. And that's really not right. If we're going to order a survey, we need to have the obligation to pay for it, whether we close the deal or not.
Exactly.
And of course, the problem with that is there are some investors who want to avoid any liability whatsoever.
Mm-hmm.
So we always try to do the right thing out there in that regard. So let's talk a minute about just some of the charges and fees that an investor might see from a title company out there.
Sure.
So we talked a little bit earlier about the owner's title policy and the
Mhm.
mortgagee's title policy.
Yes.
And guys, as investors, when we are buying a home, so often we agree to pay all the closing costs. And so if that's the case, we're going to be paying for the title policy, right? Whether
Yes.
it's the OTP or the MTP. What other fees might an investor be looking at on a settlement statement?
Standard charges assessed by the title company, obviously the owner's title premium, and it's going to be a little less than 1% of the sales price.
Mhm.
Your mortgage title policy, if you purchase those together, it's going to be an additional $100 plus endorsements.
Okay.
And escrow fee, that's standard. It's going to be a little bit different according to the market and title companies, around the state.
I'm going to stop you. I know you're on a roll.
Mm-hmm.
But I've seen escrow fees from, one part of town might be $300 per side. If you go to a little more highfalutin side of town where prices are higher, that escrow fee all of a sudden goes to $400,
Mhm.
$500, $600 per side. Not sure why they do that. The workload's not any different.
Mhm.
They can just get away with it, right?
Essentially they can back up, the paper costs and things like that. That's kind of the way that they go. But honestly, I don't know exactly what regulates the $300 fee versus a $500 fee.
I think
But
it's
yet we've seen that spread.
Yep, it's just what we want to charge sometimes.
Mhm.
So I get that. What else we see out there?
Legal fees, most definitely. If we need to get an attorney to come in and help us and do something, advise the customer, or file certain things that I can't do as an escrow officer, then there's going to be a bill for legal fees. They're going to need to pay the attorney who's doing that work.
So can that be things like for maybe a note and a deed of trust?
Yes, legal doc preparation,
Deed.
curative preparation, and heirship affidavits like we talked about before.
Right.
And also filing those homestead and lien release waivers for abstracts of judgment. That's something that
Okay.
you may bill for.
I got it.
And curative work kind of circles all that back up in, if there was a deed that was recorded, maybe they had the name wrong. Maybe they had the previous deed of trust amount wrong.
Right.
We would need to re-record that deed in order to correct title before we can record our new documents.
Mhm.
That's going to cost you. Obviously, in the proration of taxes, rents, anything that may be outstanding that needs to be allocated between the parties, we'll collect that at closing. Tax certificate, we definitely have to pay our third-party vendor who lets us know what the taxes are.
Okay. And I guess if the borrower is getting a mortgage loan, that lender may have fees, and that's going to be on there too,
Yes.
disclosed in some format. So there's all sorts of fees we got to look at for. Now, one of my biggest pet peeves of the title industry is what I call junk fees.
Mm-hmm.
I don't see a lot of those today, and they're just miscellaneous fees that show up that you wonder, well, what is that fee for?
Mm-hmm.
What do you see out there? What have you seen?
I've seen, copy fees, we get courier fees, basically they're just adding fluff to your statement as opposed to actually charging you actual charges. We definitely make that practice of charging actual charges. If we're going to incur a cost, we may pass that cost on, but we're certainly not just going to add fees to collect from you if it's not an actual service being performed.
That's the way it's supposed to be, right?
Correct.
Now, I don't mind you charging those junk fees when possible. If you look at these boots I'm wearing right now, Daddy needs new boots or something along the way. But, be cautious, guys, and look at that. If you're just doing one deal and you're getting charged an extra 10 or 15 or 20 bucks, it's not a big deal. If you're doing volume, and I remember back in my day when we were closing 20 plus transactions a month, every month, and you're doing 400 or 500 type of transactions a year, maybe buying and selling,
Cost
that
up.
$10, $20, $30, $40, $50 per transaction becomes a big number
Most
when you look at it on a year-long basis that's out there. Then I guess there's always going to be commissions of some type
Mm-hmm.
that get charged out there. And I find this really interesting, Cassie. I'm not sure if you know this or not, but I've only had this happen once in my 30-something year career of being a real estate attorney and title attorney. And that is where the seller said, do not pay commissions on the settlement statement.
Mm-hmm.
And here in Texas, guys, if you look at a standard Texas real estate commission contract, a TREC contract, you'll notice that the commission page is behind the signature page of the contract. Once you sign that contract, everything before it is part of the contract.
Mm-hmm.
Everything after the contract is either an amendment or is superfluous. And this is not incorporated into the contract anywhere. Title companies provide a courtesy of collecting real estate commissions and dispersing at closing. But in reality, when a seller signs a listing agreement,
It's his responsibility.
it is the seller's responsibility to pay the agent.
Mm-hmm.
And of course, everybody, and I mean everybody, thinks it goes through the title company. But we had this one seller say, do not pay commissions. I will pay them outside of closing as per my agreement.
Mm-hmm.
We had to honor it. Blew me away, because that was new to me as
I
well.
haven't seen that. That's very interesting.
And, when we get to closing, let me tell you what. The buyer's agent was not a happy camper.
I imagine.
Nor was the seller's agent.
They were hoping to get paid that
They're
day.
hoping to get paid, and now all sorts of things were opened up.
Mm-hmm.
But we had to explain to them what was going on, and I had to go to underwriting and ask, what in the world was he asking?
Mm-hmm.
And it was eye-opening. One of those rare things you don't see too often out there in the industry.
He's a smart man. You're reading his contract.
Yes. Now, you get out there a little bit too, Cassie. The other thing I see so often in our industry is buyers and sellers come in and they think you are going to walk them through this transaction, explain everything to them, and give them all this advice.
Most definitely.
What's reality?
A huge misnomer.
It is.
I'm not an attorney, and I state that gladly. I'm happily an escrow officer.
How gladly do you state that, by the way?
I like that you handle the attorney stuff. I handle the title stuff. We stay in our boxes. It works well. So it keeps me out of trouble for not giving legal advice. But I can discuss the facts of a transaction. I can state, a brief description of what something is,
Right.
but I'm not going to interpret its purpose or its meaning.
That's really well put, by the way.
Thank you.
You can tell somebody, hey, this is your note.
Mm-hmm.
This is your obligation to pay. But you can't go into detail and explain the legalities.
How it's going to be applied.
Yeah, this is a deed of trust or security instrument. This creates a lien on the property.
Mm-hmm.
You don't get the chance to go through and explain rights or benefits or obligations of the various parties involved.
Exactly.
You know, so often I find though that buyers and sellers, whether they're investors or not, want to ask this information and get it, and they kind of put title officers in a tight spot.
Yes, they want us to advise them. They want us to, give them that pat on the back and make them feel comfortable with what it is that they're doing. And unfortunately, as the escrow officer, that's the exact thing I cannot do. So that would definitely be a position for the attorney where they would need to, and I would refer them at that time. Hey, this is a conversation that you need to have with Scott. He can certainly address those concerns with you, but I cannot give you legal advice.
There's only one problem with that though, Cassie. Nobody, and I will say nobody ever wants to pay for it.
That is correct.
They all want free legal advice.
Yes, sir.
And by the way, sometimes that's great marketing. We try to help our clients that way any way we can out there. And I guess to wrap up that little section, the best way to describe it is just the facts.
Mm-hmm.
Keep it simple.
Mm-hmm.
Explain things, and have a good understanding, guys, of what escrow officers can and cannot do out there.
It's very
Now,
important.
I think learning how to draft a contract as well, guys, is very important. So when you bring it to a title company, you know what to expect, because what you put in your contract will determine what the title company can do. If it's not in there, they can't do it. If it's omitted or is included, they have to follow what we put in our contracts. They can't go out there and make assumptions to do X, Y, or Z. So, if you want something, ask for it. If you want the seller or buyer to pay for something specific, ask for it.
Put it in writing.
Read your contract, put it in writing, right?
Yes, there's
Go
no
through it.
agreement in the state of Texas.
You try to, the contracts here, at least the promulgated forms, try to address most of those issues. Who pays for a survey? Or maybe you have an existing one. Who's going to pay for the drafting of the warranty deed? Who's going to pay for the lender fees?
Mm-hmm.
Who's going to pay for curative fees maybe? Or things like this. And you just need to have a basic understanding of who's going to do what out there. And it doesn't always happen that way, right?
Right, there's often amendments, things change day of closing, but the bottom line is we have to have the agreements from all parties and in written form in order to proceed.
One thing I like today at least is, because years ago, it used to be that we as a title office, we would send a payoff check with a release of lien to the mortgage company. We talked about this earlier. They would get it, they'd sign it, and they'd send it back to the seller who's supposed to record it.
Mm-hmm.
They never did. Today, they changed regulations on it a little bit. So now the lenders are going to include that release of lien fee. They are required to not only execute it, but to record it themselves for that very purpose. So again, they got it right.
I'm very excited about that.
Yep. Be sure you execute things like occupancy. When are you as a buyer going to take possession? At closing, before or after closing, pursuant to some document maybe that's out there? You need to know that. And again, keep in mind the basic things about tenants, because you've got tenants in the property. Are they going to move out, not move out? Be proactive and understand the basic things out there. So let's wrap this up a little bit with what are some of the problems that we see out in the marketplace. We have to deal with HUD. We have to deal with RESPA, the Real Estate Settlement Procedures Act. In the title world, we got to deal with the Texas Department of Insurance, or if you're in another state, they have to deal with their insurance department that runs and regulates title companies.
They're highly regulated.
There are assignment regulations, right?
Yes.
That you have to look at. And we talk about, I've seen out there so often that if a buyer is taking an assignment of the property and they're getting a mortgage loan, that lender may not allow that assignment.
They're not going to approve that type of a transaction.
No, they want to see that the actual seller is entitled first before they do it.
For a certain period of time in some cases. And in most cases, they also want to see that somebody's going to be occupying that property.
Yeah. Now, that's usually in the mortgage world. You come up to the small commercial bank world or to the private lending world, they don't care so much about that. But
they're going to be paid back a lot quicker. They're not putting their foot out there for 30 years in most cases either.
That's maybe one of the reasons. You have flip regulations. Now, if you're going to buy a house on, let's say, January the 1st, you're going to rehab it and sell it, and all of a sudden you have this huge upswing in price. lenders don't like that, especially if you've held the house very short term, and as investors, our goal is to hold the house short term to limit our interest carry
Right.
and costs and expenses.
One of the red flag tests will pick up a lot of these transactions a lot quicker.
So, there are Fannie Mae rules and Freddie Mac rules are kind of the same. You mentioned earlier the one about the Texas Department of Insurance that says that if the profit being realized is 15% or more of the tax assessed value
For the assignment fee.
for the assignment fee, underwriting.
We have to get approval, we cannot
As
close
long
that
as we approve it.
transaction. That's,
Yeah.
when I get an assignment contract, that's the first thing I'm looking at, is to verify if your numbers are in order. If not, we're gonna go to underwriting to get that approval if needed.
And you have to know that, especially in our world, it is a requirement and regulation in which the specific office could have liability if you don't do this kind of thing.
Mm-hmm.
And that is one of those things that came out of the subprime era out there.
More bad apples.
More bad apples. There's what I call the 90-day rule that's out there. That stems from a Freddie Fannie type transaction where if you buy a home foreclosure, you can't necessarily resell it for 90 days.
Mm-hmm.
Or if you do sell for 90 days, you're limited to the profit you can make. And you've got to be smart in looking at this stuff a little bit.
Mm-hmm.
And again, this didn't exist prior to 2009, and it all came into play because of the things that went on back then.
Mm-hmm.
Those few bad apples that happened out there.
Yep.
There are double closing issues. We talked about those a bit earlier
Mm-hmm.
that we have to think about as investors. What does the Department of Insurance require us to do? We don't want to get stuck in a mortgage fraud scenario.
No, not at all.
But
We don't want to be able to show up back to work tomorrow free.
we do, and it used to be rampant prior to 2009 out there. And there are ways that sometimes we can transact this. Another thing that I find that the investor community doesn't know is that if they buy a house on the first of the month
Mm-hmm.
and they record a deed, unless they're closing the sale in the same title office, they have to wait for that county where they close to certify
Mm-hmm.
the deed.
Takes time for them to pick that up and actually provide that indexed image.
Yeah. In your major counties, that's usually about 10 business days.
Mm-hmm.
Smaller counties maybe a bit less. But just because you close a house on Monday doesn't mean you can necessarily close it Tuesday at another title office
Very
because that deed hasn't been picked up yet. So there's some lag time is how I guess I describe the
Mhm.
issue out there. I know we get it, but most people don't even know that exists out there.
Mm-hmm.
And they don't understand why we have to slow them down when they want to turn their deals.
Well, in some cases, if the county has an issue, I know that Dallas County, at one point, their basement flooded. That's where all their records were. So we were even well beyond the 10 days because they couldn't get to what they needed to produce that information so that we could then get them certified dates.
Another thing I see out there is that it adds cost and expense, but also takes time and is a problem, is if you have a probate scenario
Mm-hmm.
where you have multiple heirs,
Yes.
or maybe you have 5 heirs, 6 heirs, 7 heirs, maybe 2 died, and they have multiple heirs that
Mhm.
may have inherited this property along the way, we have to stop and not just check the title of the property, we have to search every heir downstream who may have an interest in the
There's
property.
a potential that their liens could attach to the property.
And we gotta deal with those, right?
Yes.
And there's all sorts of issues along the way that deal with that too. So for more on that, guys, take a moment and visit our probate class too, and maybe you'll learn a bit more about that what we as investors need to know about probate along the way. Now, lastly, Cassie, we kind of got our hands tied behind our back several years ago.
Mm-hmm.
I'm not exactly sure when this thing that here in Texas we call Rule P53 came down,
Yes, sir.
but tell me a little bit about that. What do you know about that good old rule?
So essentially, you can't buy business. If I've got X amount of dollars and I want, this
Why?
customer, well, because they said that it's not fair. It's not fair for all title companies. We're essentially all providing the same service and the same product. So if I'm paying more money than title company B down the street is, well, I'm going to get more business than them. So yeah, the state did come in and regulate, and they said that there are certain dollar amounts that you can pay for certain activities, and then there's certain activities that you can't contribute to at all. That way that there is an level playing ground.
Well, they made it kind of evil, unfortunately.
Yes, that
You know
was a
what?
nice Freudian slip.
What I kind of remember is that what they came out and literally said was that the title industry was literally prostituting itself to the realty industry. Literally going to realtors, giving away gift cards, trips, this, that, whatever it might be.
Spa days.
Spa days, absolutely.
Trips, all
I
of
didn't get
it.
any of those, by the way.
Me either.
But they were actually out there buying the business, and TDI has said, we are done, and they shut it down. And when they shut it down, they really shut it down, where they limit what we can do. Just things that I kind of remember a little bit, because I haven't read this thing in a long time. No, I can only take one client to lunch 4 times a year. And I'm limited to like $25 max I can pay for them.
Per time.
So you can't take them out and buy them $200 lunch. I'm not sure where you do that, or how you eat that much, but I guess you can. But they did not want us to go out there and do that. You know, and I pride ourselves on trying to provide quality of service, and expertise that you can't get in so many other places.
I'd like to think that the service that we provide is more than a monetary value. You know, we're giving them something that can't just be purchased from the title company down the street, because we truly care and we truly look into it, and we're here for, you know, the best interest of all of our customers as well as the title company itself.
Yep. You know, one of my philosophies is that if we can't fix the problem, no one's going to make any money. And just because you take a contract to company A, B, or C, are they really going to be as proactive in that as we are?
Right.
I don't know. Sometimes yes, a lot of times no. Are they going to know all the ins and outs like we do to solve our problems so we can get that deal closed, so we can either flip the contract, buy the property and rehab it and resell it, what it might be? And I do think that's the case. I think that when you can provide a higher quality of service, a more friendly atmosphere, and expertise that they can't get anywhere else, that's what's going to wind up selling us as a title office in the industry.
Most definitely.
And I don't really want to go out and buy that business. I want to take care of my clients however I can. I want to be friendly to them, give them some free marketing here and there, whatever it might be, and advice if I can to help get it done. But I don't want to buy their business.
Yeah, it's about providing a good service. You know, you want them to want to come back, not be bought to step foot in our doors.
So guys, I hope that really helps you a little bit on the title industry, on some basic issues that come up out there on a day-to-day basis that we as investors have to know. So thanks for taking the time and listening to us. Hope it helped you guys understand more about the title business. Cassie, thank you so much.
Thank
You did a
you.
great job.
It's a pleasure to be here.
Guys, have a great time. Hey guys, if you liked this video and want more free information on owner financing, please subscribe to our channel and hit the notification bell to be notified when we post. Don't forget to like this post and ask me any questions on owner financing below. When you're ready to take the next step, head over to the ownerfinancenetwork.com and check out our in-depth course on owner financing.